morality is part of the criminal law, but that the law doesn't criminalize all things that are immoral. And it is only when something is so wrong that it violates public order and blameworthy enough that it deserves penal sanction that the criminal law is going to step into place. An Ontario Court of Appeal decision from the 90s talks about conduct which is mean, petty, uncooperative, and spiteful is not the stuff of criminal law, and that it's a blunt and costly instrument. So it has to be used as a instrument of last resort, and that there ought to be restraint implied. And for this reason, not everything that we would think is bullying or not very nice behavior that happens between students at a school, for example, is something that the criminal law should get involved in. And so back in 2015, or prior to 2015, the federal government has a federal, provincial, and territorial working group on cybercrime, and they were looking at amendments to the code to cover things like cyberbullying. And what they basically decided was that for the most part, the criminal code already covered things, most types of things which rise to that level of being blameworthy enough that the criminal law should be involved. But they did find that there were one or two exceptions and changed the law a bit. And one of the exceptions that they found, or the things that wasn't covered very well, was this idea of revenge porn, or where someone has intimate images of a person and then decides to share those intimate images with people who are beyond what the person who created the material in the first place intended. In the beginning, when I would get these phone calls, I would get them because, as we'll talk about in a little bit, where the people in the material are under 18 years of age, the material often amounts to being child pornography. And so possessing it, looking at it, sharing it with other people are all criminal offenses because the material is contraband by being child pornography. And because I was dealing with those types of cases, I would get the phone calls when it was people who were over 18 years of age and those pictures were being passed around. And so there were a number of different things that we looked at in terms of what offenses could be charged. And there were one or two people in Toronto or the Toronto region who were charged with an offense of defamatory libel. Defamatory libel actually has been in the criminal code for hundreds of years, and it actually came about to deal with the problem of dueling. And so instead of having to challenge someone to 6 guns at dawn if they did something that you didn't like, you could have a charge of defamatory libel laid against them, and then you could go into a court and deal in a courtroom with defending your honor. There are two types of defamatory libel in the criminal code. One is libel which is known to be false, and that is still constitutional, not a violation of freedom of expression where you're saying something publicly for the purpose of exposing someone to hatred, contempt, or ridicule when you know it not to be true. But the other offense in the criminal code covers that same type of communication, exposing someone to hatred, contempt, or ridicule where it's not known to be false. And that offense is still in the criminal code, but it's been declared unconstitutional in 3 different provinces, and in Ontario has been unconstitutional since 1996. When we're dealing with actual recordings or pictures of people engaged in sexualized situations, clearly we're not dealing with something known to be false, and so it doesn't fall within the defamatory libel section of the code, or at least not the one that's still constitutional. Another offense that was looked at in terms of covering this type of behavior was the offense of criminal harassment. Criminal harassment requires or says that no person shall, without lawful authority, knowing that another person is harassed or being reckless as to whether the other person is harassed, engaged in conduct that causes the other person reasonably to fear for their safety in all of the circumstances. The conduct, there are 4 different types of conduct, and the 2 that sort of tend to apply in these types of situations are subsection B, repeatedly communicating with, directly or indirectly, the other person or anyone known to them, or engaging in threatening conduct directed at the other person or any member of their family. And when you think about that, if someone is sending emails to a bunch of people that you know with these intimate images of you in them, it maybe fits into the repeatedly communicating part. But if it's a single upload to some sort of website, it's harder to cram it in or have it fit into the criminal harassment definition. But the bigger problem that I always found in dealing with people when this happened is when the police would talk to them about how they felt about what had happened, they would talk about being annoyed or harassed or bothered or upset or embarrassed by what was going on. But very few of them would talk about fearing for their safety, which is obviously what the section requires. There are cases, though, where this was criminal harassment was successfully used to deal with the dissemination of these types of images. In one particular case, a case called Corbett, a woman's pictures were sent around to the people she went to church with, she worked with, her family. And in fact, the offender in question had even taken out a Craigslist ad pretending to be her, saying that she wanted people to show up, random strangers to show up at her home and have sex with her, and random men did start showing up at her house. So you can see where, on the particular facts of that case, the circumstances would be such that a reasonable person would fear for their safety. But there's a great quote from the court in that case where they talk about the idea that to argue that a woman who has had her most private and intimate personal images distributed electronically to every friend, relative, and church attending associate has not suffered a grave and serious fear inducing harm is to ignore the perspective of women. So, where we did have victims who were able to talk about how they felt and that they feared for their safety and why, criminal harassment was an offense that we were able to use. But quite often, as I said, that's not the way that victims would speak about it. Another offense that often came up in these circumstances was uttering threats or extortion. Sometimes people who have these images will threaten to send them around to other people or to post them on the internet if the person in the images doesn't do something. If you don't continue to be my girlfriend, if you don't have sex with me, then I will send these pictures around to your parents or around the school or whatever it is. If that's the situation, that amounts to uttering threats or extortion. But if you just post the material without making the threat or trying to coerce the person into doing something, it doesn't fall within that section. Identity fraud is another example of that. As I was just mentioning, the case where the person pretended to be the person in the pictures and shared the pictures and sort of said, this is me, I want people to come to my house. That might amount to being identity fraud. But that requires that you're personating another person with intent to gain advantage for themselves. And sometimes it was hard to fit the purpose of it or to prove what the intent of the person posting the material was. And so identity fraud wasn't always a good fit either. Similarly, unauthorized use of a computer or mischief in relation to data can be the case if someone hacks into your Facebook account and steals the pictures or pretends to be you. There are those types of offenses. But quite often what we're talking about is material that was willingly created and provided to a person. There wasn't any stealing or theft of it or taking it without knowledge. And it's what happens after that that becomes the problem. And again, these sections sometimes applied, but quite often did not. As I mentioned before, though, where the people in the material are under 18 years of age, it most often meets the definition of child pornography, but where people are over 18 years of age, it didn't fit very well. And as a result, in 2015, the federal government passed an amendment to the criminal code and created the offense of non-consensual distribution of intimate images. I just put this up because when I teach the police, it always makes me laugh. The police officer said the posts weren't illegal, but retracted that after reading the criminal code. I think it's important to always know what the criminal code says. The act or the section, the offense, came into force on March 10th of 2015, and that's an important date because if the material was made available on the internet sent to someone prior to March 10th of 2015, then the section doesn't apply. Criminal offenses are not able to apply retrospectively. So things can only, a new crime can only cover activity that occurs from that date forward. So the date of March 10th, 2015 is exceptionally important, because if it happened before that date, then we're back to the situation before, where we have to ask, was there a threat? Was it repeated contact? Did the person fear for their safety in the hopes of trying to fit it into one of the other offenses? The act that came into force and amended the criminal code in March of 2015 was the Protecting Canadians from Online Crime Act, or Bill C-13. And it was the result of that working group I mentioned that was looking at the possibility of creating an offense of cyberbullying. The offense that they came up with, we'll talk about in a minute. But when I told you that it would only apply to offenses that took place after, or things that were made available after March 10th of 2015, the other thing they added in addition to the offense was they added a non-consensual distribution as an offense for which you can seek a peace bond under Section 810 of the Criminal Code. So where you have someone who is afraid that someone will distribute an intimate image of them in the future, they can go to court and seek a peace bond against that person to stop them from doing so. And conditions of the peace bond can include things like having to get rid of any of the material that they have in their possession, etc. And the article from the paper that's on this slide is an example of a case I dealt with where that was exactly the case. The images in this case had been posted prior to March 10th of 2015, so we couldn't, police couldn't lay a charge of non-consensual distribution, but we were able to persuade a court that the fact that he had made these types of material available prior to March 10th gave people reason to fear that he might well do the same thing post March 10th of 2015, and thus might commit a non-consensual distribution offense. And as a result, I should note, he actually consented to the imposition of the peace bond, but the court had no difficulty having him enter into a peace bond on that basis. So what is the offense of non-consensual distribution? Section 162.1 of the Criminal Code makes it an offense to knowingly publish, distribute, transmit, sell, make available, or advertise an intimate image of a person, knowing that the person depicted in the image did not consent, or, and this is the really important part, being reckless as to their consent, which means the onus isn't on the person in the pictures to tell you no, or to tell you that you don't have their consent to distribute that material. I would say this section makes it clear that the person sharing the material has an obligation to have consent, to make sure that it's okay with the person who is depicted in the material. Otherwise, they are being reckless as to whether or not there is consent. When we talk in a minute about how this section is similar to, or not similar to, excuse me, child pornography offenses, one of the big differences is that it is restricted, is only an offense to publish, distribute, transmit, sell, make available, or advertise this type of material. It is not an offense to possess it or to access it, both of which are crimes that can be committed with respect to child pornography. Just having this type of material, someone who downloads an image that was shared without someone's consent and has that on their phone or their computer, they are not committing an offense under this section unless they too publish, distribute, transmit, sell, make available, or advertise that image. So it's a much more restricted in terms of criminalizing only certain things that you do with this type of material. So what is an intimate image? An intimate image is a visual recording of a person made by any means, including a photographic, film, or video recording. Again, this alone makes it very, very different from child pornography. The child pornography section of the Criminal Code covers visual representations. And the Supreme Court of Canada, in a case called Sharpe, has said that that means it's broad enough to cover any textual representation that can be perceived visually, which means it covers drawings, it covers sculptures, it covers anything that is you can see visually. And because of that, it doesn't have to involve a real person. So it can involve anime or hentai. It can involve, as I said, sculptures or childlike sex dolls. All of those things may meet the definition of child pornography, but they aren't visual recordings. So the fact that it requires a recording means, by definition, that it requires that it be something that actually happened. So another instance or thing that can be child pornography is when someone takes the heads of children and photoshops them onto the bodies of either adults or other children engaged in sexual activity. That child whose face is there never engaged in that activity. And that is a visual representation of that person, but it's not a visual recording of them. So the section, again, is limited to material that actually records or documents something that really happened. I don't know if any of you have read on in the news or seen on television, but there's something that's being developed, or an app that's being developed, that they're calling it deep fake, which will actually enable people to Photoshop or morph people's heads onto the bodies of other people in movies. So it's always been possible to do this with pictures, or has been possible to do this with pictures for some time. But the technology is being developed now where you could take my head and put it on the body of Fay Wray in the King Kong movie. And so I think we're going to see a problem with this section going forward, because if we're talking about an intimate recording that nobody else is able to distinguish whether it was really me or my head photoshopped onto the body of someone else doing this, I'm not sure that the impact on the person in the pictures is any different. And yet the section will only cover things that actually happened. So again, that's an important distinction between this and the child pornography provisions. But the visual recording obviously isn't enough. It has to be a visual recording of a person in which the person is nude, exposing his or her genital organs or anal region or her breasts, or engaged in explicit sexual activity. Again, these components are similar to the provisions of the child pornography sections of the criminal code, and yet they're not. For example, a picture of a person who is nude is an intimate image. In child pornography, nudity isn't required, but a sexual purpose for the picture is required. So having a picture of your 6-month-old baby in the bathtub with no clothes on isn't child pornography, because that picture is not being possessed for a sexual purpose, for the most part, let's hope. But it would be an intimate image because the child in that, or the person in that picture, is nude. So the nudity is a requirement of one subsection or one part of the definition of intimate image, but there's no purpose for it. It doesn't have to be for a sexual purpose. And again, that makes it different from child pornography. The recording can also be of someone who is exposing his or her genital organs or anal region or breasts. The child pornography section of the code uses a different word. It talks about sexual organs or anal region and doesn't specifically delineate anybody's breasts. So the courts have held that sexual organ in the child pornography provisions of the code includes breasts. Why they felt the need to separate it out back into genital organs or breasts of a woman, I'm not clear, but it is different. In terms of the anal region, that is the same term that is used in the child pornography provisions, and that has been held to mean the area around the anus. And the law has held that the anus itself does not have to be visible in order for the picture to be a depiction of the anal region, that it obviously means more. If they'd meant to say anus, they would have said anus. And in fact, your anus may or may not be viewed as being a genital organ in and of itself. So the anal region has been held to mean more than that, and has been held in child pornography cases to include the buttocks. But the important distinction here, besides the difference between sexual organs and genital organs, is that this section requires that they be exposed. So the child pornography section does not use the word exposed, and as a result, the courts have held that photographs of children wearing bathing suits or lingerie or even diapers can meet the definition of child pornography. This section, however, requires that the genital organs, anal region, or breasts be exposed. So a person who is distributing pictures of their intimate partner in their underwear, let's say it's an ex-girlfriend and she's wearing a lacy bra and underwear, that arguably would not be them exposing their genital organs or breasts because they're clothed. I guess it would depend how translucent or transparent or lacy the material was, and the Crown might be able to argue that. But there's a big difference in the word exposed being used in this section when it's not used in a way it's not used in the child pornography provisions. And then lastly, it can be someone who is engaged in explicit sexual activity. You'll notice that nudity or exposed genital organs, etc., is a different section. So this would seem to mean that if you're engaged in explicit sexual activity, it doesn't matter what you're wearing or how much of your body is exposed or not exposed. The Supreme Court of Canada, again in the child pornography context, has told us what explicit sexual activity means. And it doesn't mean all sexual activity. They have said that it's acts involving, in the child pornography context, in Sharpe, they said that explicit sexual activity is acts involving nudity or sexual activity at the extreme end of the spectrum. They go on to say they're not going to try to define everything that means, but they do say that it probably doesn't mean a kiss. So in the child pornography context, they talk about how two teenagers kissing at summer camp probably wouldn't amount to explicit sexual activity, that it would require something more than that. The types of sexual activity that have been found to meet to be explicit sexual activity, at least in the child pornography context, include acts of intercourse, be they vaginal or anal, cunnilingus, fellatio, and even acts of urophilia or coprophilia. So anything like that is viewed as being an act of explicit sexual activity. Again, the wording here is different from the wording of the child pornography provisions of the Criminal Code, because the section for child pornography talks about a person who is or is depicted as engaged in explicit sexual activity. So again, that means that where you take the head of a child and put it on the bodies of other people engaged in sexual activity, you are depicting that person as engaged in explicit sexual activity. That would meet the definition for child pornography. But that same image is not a depiction of that person engaged, or recording, of that person engaged in explicit sexual activity. And so it would not meet the definition of an intimate image. So it's important to remember that whatever looks like it's happening in a picture for an intimate image has to have actually happened. And in the child pornography context, it doesn't matter whether it happened or not. What matters is what it looks like in the picture. So it's an odd thing in that the definition of intimate images is in some ways broader and captures things that the child pornography section of the code doesn't capture, and yet it's also narrower and doesn't capture things that the child pornography section of the code does. One important thing to note is that the section does not exclude material that is child pornography. There's another section of the code which is called showing sexually explicit material to a person under the age of 18 for the purpose of committing a sexual offense against that person. It's sort of a grooming behavior that doesn't have to happen online. It can happen in the real world. And it's the idea that when you're showing someone under 18 sexually explicit material, that you're trying to groom them for engaging in some sort of illegal sexual activity with you. I have lost my train of thought. Yes, so the definition, though, of sexually explicit material specifically excludes child pornography. So it says that sexually explicit material is material in which, and then it talks about very similar things to the definition of intimate image, but it requires that they not be child pornography. That isn't the case for the intimate image offense, which means that even where somebody is under the age of 18, the police or the Crown can deal with the case as a non-consensual distribution of an intimate image instead of a child pornography offense. So it's an important distinction here that they did not, the legislation does not exclude material which meets the definition of child pornography. The other part, though, of the definition of an intimate image that's extremely important is it's not just the content of the recording which is required to meet the definition, but the court or the legislation requires the court to look at the circumstances in which the material was made and what happened to the material between when it was made and when it was ultimately distributed. So subsection B requires that at the time of the recording, there were circumstances that gave rise to a reasonable expectation of privacy. So a picture of somebody who's naked, but it wasn't made in circumstances giving rise to a reasonable expectation of privacy is not an intimate image. I'll give you an example. 2 or 3 years ago, you may remember some articles in the news about a couple who were engaged in an act of sexual intercourse on a streetcar going across Queen Street in downtown Toronto. As you might imagine, other people on the streetcar pulled out their cell phones, took some pictures of this, and shared them around social media. I think that it would be hard for the Crown to argue that at the time of that recording, the people were in circumstances giving rise to a reasonable expectation of privacy. And I think it would be hard to argue that that was, in fact, an intimate image. In addition to the circumstances in which the recording was made, the courts or the legislation requires that the court look at what happened to it in the meantime. Subsection C says that it has to be a recording in respect of which the person depicted retains a reasonable expectation of privacy at the time the offense is committed. And I think retains is a really important word because what it seems to imply is that if at any point you give up your reasonable expectation of privacy in that particular image, you can't get it back. It doesn't say that you have it at the time the offense is committed. It says that you retain it. And I think what this was meant to cover was where you have a couple who are engaged in a consensual happy sex act, if you will, that was recorded with the knowledge of everyone involved, and they share it on some sort of an amateur porn website. Even if they take it down, if somebody after the relationship ends takes that video and posts it somewhere else again, my view is the fact that it had been posted with everyone's consent and knowledge means that the reasonable expectation of privacy is probably gone. And it would be very difficult for the Crown to argue that anyone in that material retains their reasonable expectation of privacy. I've been talking a little bit about the definition of child pornography, and this slide just sets out that what it is. As I said, it's a photographic, film, video, or other visual representation. So that's much broader. And then there's two different ways that a visual representation can be child pornography. It shows a person who is or is depicted as being under 18 years of age, and is engaged in or depicted as engaged in explicit sexual activity. Or its dominant characteristic is the depiction for a sexual purpose of the sexual organ or anal region of a person under 18 years of age. So you can see how that's similar to and yet different from the language used in the non-consensual distribution sections of the code. We've talked a little bit about this before, but obviously the child pornography provision only applies to people who are or are depicted under the age of 18. What this means in most cases is that whether or not something is child pornography depends on whether a reasonable person looking at the material would think that the person is under 18 years of age. So it's an objective, reasonable person test, unless the person who is being investigated or charged knows the person in the material. So where you've got an 18-year-old boy who has pictures of his 17-year-old girlfriend, it doesn't matter, and is passing those around. It doesn't matter that no one else looking at those pictures would necessarily know that she is under 18. What matters is that he knows that she's under 18, and therefore it would amount to child pornography. The dominant characteristics section, as I said before, it has to just be for a sexual purpose. So nudity alone would meet the definition of an intimate image. It does not meet the definition for child pornography. On the broader part, as we talked about, it doesn't have to be real. It doesn't have to have really happened to be child pornography, whereas it does for an intimate image. Nudity isn't required. And as I spoke about before, it's a criminal offense not just to share child pornography, but to possess it or to access it. The other important thing to remember when we're dealing with child pornography or images that might be child pornography is that it is not necessarily illegal for teenagers to have naked pictures of their intimate partners. When the child pornography provisions came into force in the early 1990s, they were eventually challenged, and the Supreme Court of Canada heard the appeal in 2001. And it was the first offense, child pornography was the first offense which criminalized possession of material that was obscene. The obscenity provisions of the code, which was how child pornography had been dealt with up until that point, only criminalized the publication or possession for the purpose of publication or sale, etc., of obscene material. It wasn't a crime to possess obscene material, and it was, or it became a crime to possess child pornography. So when the court looked at this, they held that the section did in fact violate people's freedom of expression, but that for the most part, it was justified or saved as a reasonable limit in a free and democratic society. But they did carve out two exceptions. So one exception is where it's wholly self-made material. So we haven't talked about it, and we're not going to talk about it too much, but written material that counsels or advocates sexual activity that would be an offense under the Act, or that describes for a sexual purpose sexual activity with children that would be a crime under the criminal code, that's illegal as well. But where someone just writes a story like that themselves and keeps it for their own use, the Supreme Court of Canada said that that would be an exception, and that would not be criminalized. It would only be where they shared that type of material with someone else that it would become a criminal act. With respect to visual recordings of sexual activity with people under 18, the court said that there should be an exception, and it's referred to often as the private use exception or the common law exception or the Sharpe exception, or now the Barabash exception. But it means that material which shows people under the age of 18 engaged in sexual activity where the sexual activity is lawful, everyone consented to the creation of the material, and the material is possessed for the personal or private use of those involved, then that does not meet the definition of child pornography in the criminal code. So if you have two 16-year-olds who engage in consensual sex and they record it, with the consent of both of their parties and they keep it just for themselves, then they are not in possession of child pornography. But as soon as they share that material with someone who was not in the material or didn't make the material, then the defense or the exception no longer applies, and those people are accessing or possessing or making available child pornography. There's been a lot of discussion, though, about is it appropriate to lay child pornography charges against people who are under 18 years of age themselves? And what do you do, as quite often happens, when the entire grade 11 class at your local high school has this picture and is sending it between each other on their phones? And I worked with the Canadian Centre for Child Protection on developing some materials for schools and for parents. And one of the things that we talk about in those materials is the importance of distinguishing stupidity from malice. I don't for a moment think that there aren't people under the age of 18 who can be just as predatory in their behavior, and if you read some of the cases, clearly as predatory in their behavior as people who are over 18. But there are also other people who get involved in this who don't necessarily understand the criminal aspect of what they're doing or the impact that it's having. And the important thing to remember is that the police have to have reasonable grounds to believe an offense has been committed in order to lay a charge. So even where they have the appropriate grounds to lay a charge, they still have a discretion not to lay that charge. For the Crown, even where the police have laid the charge, the Crown has to have a reasonable prospect of conviction. And part of that analysis is that the prosecution has to be in the public interest. And I'm not certain that it is in the public interest necessarily to lay a charge of distribution or making available child pornography against 100 students at your local school. What I think is important, though, is for the police and the Crown and the schools to not think about this as an on-off switch, to not think about we either do nothing or we lay criminal charges against everybody and proceed full bore with a prosecution. I think it's important for us to think of our response to this more in line with a dimmer switch, that there are things we can do between doing nothing and laying criminal charges against everybody. I'm going to stop before we get to the offensive voyeurism, which I'll tell you about in a second. I think it's a bit more important to talk a little bit about what the dimmer switch aspect of this might mean. And there was a young girl in Nova Scotia who a number of years ago was bullied to the point that she switched schools and ultimately, unfortunately, felt that things had gotten to the point where she had no option and she committed suicide. There was an investigation that was reopened into the intimate images of her that had been passed around, and ultimately charges of making and distributing child pornography were laid against two youth criminals, two people under the age of 18 in that situation, both of whom ultimately pled guilty. The government of Nova Scotia ultimately held an inquiry into what had happened in the first place. And they found that the police and the Crown had erred in their understanding in the first place that the image in question didn't meet the definition of child pornography. Ultimately, when the case was reopened, charges of child pornography were laid because the image did meet the definition of child pornography. But what the report, the Siegel report, into the situation said that was even more important was this idea that there are lots of things that could have been done short of laying a criminal charge that would have been of assistance, and that sometimes the amount of court time that it takes or the amount of time that it takes for things to get to a resolution in court is such that the bullying continues in between, and sometimes doing other things in between, having education sessions at the school, having restorative justice processes take place where people are confronted with the harm that they've caused and have to make amends to the person. That all of these types of things can act to assist with the complainant or the person in the pictures not feeling as alone and not feeling as victimized. And so I really think that it's important when we're for the police and for Crowns who are dealing with these cases and for other people who are trying to assist the people in the material, that it's important to remember that there are things that we can do that can help send the message that this is wrong and it needs to stop, short of the police having to step in and lay criminal charges. And then before we get to the question part, I did want to bring to your attention one other issue that involves some of the concepts that we've been talking about with respect to reasonable expectations of privacy and whether you have them in public places, and that is the offense of voyeurism. So voyeurism makes it a crime to surreptitiously observe, including by mechanical or electronic means, or to make a visual recording of a person who's in circumstances giving rise to a reasonable expectation of privacy in three different situations. One is where the person is in a place in which a person would be expected to be nude, expose their genital organs, anal region, or breasts, or to be engaged in explicit sexual activity. So this basically means it's a crime to observe or make a recording in any change room or bedroom or bathroom. Because those are places where people would be expected to be nude or engaged in sexual activity. It's also a crime to secretly record people or observe them for the purpose of seeing them if they're naked or engaged in explicit sexual activity. So the example I'll use here is if there's a lunchroom in the office and the person who owns or the boss thinks that people are having sexual relations in the lunchroom and puts a camera in there for the purpose of recording the sexual activity, that would be voyeurism. But if they thought that someone was stealing money from the till that happened to be, or the cash box that happened to be in the lunchroom, and they hid the camera for the purpose of catching the person who was stealing the money, and they happened to record somebody having engaged in sexual activity in the lunchroom, they wouldn't be guilty of voyeurism. So the first subsection is focused on where the recording is made. The second subsection is recorded on what you intend or what the person intended to record or observe. And subsection C makes it voyeurism where the observation or the recording is done for a sexual purpose. The most recent example of this that was very recently argued in the Supreme Court of Canada involved a high school teacher who had a pen camera and was surreptitiously taking videos of female students. The videos, some of them included faces of the people involved, but the majority focused on the chest and cleavage area of only female students or one teacher in the school. And the trial judge found that that the students had a reasonable expectation of privacy at the school, but that there was no proof beyond a reasonable doubt of the sexual purpose for the recording. The Crown appealed, and on appeal, the Ontario Court of Appeal held that the sexual purpose was pretty clear, given the gender of the people that he filmed and the body parts that he filmed. They had no difficulty in saying that the recording was done for a sexual purpose. But they did say that these young girls did not have a reasonable expectation of privacy in a school. In fact, what they said was if a person is in a public place, fully clothed and not engaged in toileting or sexual activity, they will normally not be in circumstances that give rise to a reasonable expectation of privacy. They did say that if someone is filming upskirting, which means someone's using a camera to film up the skirts of people as they wander around in public. They did say that would be a breach of a reasonable expectation of privacy because they held that where you have you're wearing a skirt, you are, if you will, exerting privacy over the area under your skirt. And so you do have a reasonable expectation of privacy. I find it a little curious that they don't find the same reasoning to apply when you're looking down someone's blouse. In Australia, they actually have an offense that they call down blousing, which does make exactly that a criminal offense. The Crown appealed this idea that students in a high school don't have a reasonable expectation that their teachers are not going to surreptitiously record them for a sexual purpose. And the case was argued about 3 weeks ago in the Supreme Court of Canada. The colleague of mine who argued the case thought that the bench didn't seem very comfortable with the idea that female students don't have that kind of a reasonable expectation of privacy in school. But it'll be a few months, I suspect, before we find out for certain one way or the other. But obviously that idea and those issues of do you have a reasonable expectation of privacy in public will also impact on future cases involving non-consensual distribution of intimate images, right? Because it's not just the content of the material, but whether it was made in circumstances giving rise to a reasonable expectation of privacy and whether that reasonable expectation of privacy persists. So what the Supreme Court of Canada says in the Jarvis case is going to be very important to us in terms of understanding the full scope of the non-consensual distribution of intimate images section. Yeah. So we have about 10 minutes left. Pearl's going to have to help me here, figure out how we get back to being able to see your questions. Oh. Everyone seems to be having more difficulty with the sound, which I'm only getting those messages now, so. Okay, the question that I'm being asked is if a woman dances for a male acquaintance in bra and underwear, and then he posts it to the internet, does that count as criminal? I guess one question I would have to ask is how old are the people, how old is the person, the woman, I guess, she's the one who's dancing in her bra and underwear. They're both adults. How translucent or not translucent is the, or how sexy is the dance? And I sound like I'm being facetious by asking those questions, but they're obviously important. Because if you think about the definition of an intimate image, it requires that the person be nude, right? This person isn't nude. They're wearing a bra and underwear. Although I have often wondered, if you have your socks on and nothing else, are you nude or are you not nude? I'm not sure. Okay, so it's not translucent, it's sexy dancing, like pole dancing. Okay, so the problem is the person wouldn't be nude and they wouldn't be exposing, well, I guess it would depend on the underwear. If we're talking about a thong, then perhaps they would be exposing their anal region. Their buttocks has been held to be an anal region, so that might count there. And then the question would be, are they engaged in let's assume that they're wearing underwear that completely covers their buttocks. So they're not exposing their genital organs or their breasts or their anal region. That would leave us with a question of whether they were engaged in explicit sexual activity. And that would then come down to a question of, is the pole dancing, does that amount to explicit sexual activity? I confess I am not aware of a case that has concluded that it does or doesn't amount to explicit sexual activity. The question that I'm getting now is, if you come across a case of this nature, where can you go for further guidance or consultation? I would think you would want to contact your local police officer, who's probably going to end up calling me. But I would think if you have if you're in a school and there's a school resource officer, or your local police department, they get more of these calls than you would want to know they get. And they would be in a better position to sort of assess exactly what's going on, and what should happen. Even where we're talking about adults, I think it's important to remember that the police have to have a reasonable prospect of conviction, and then we have to have the Crown has to have, the police have to have a reasonable grounds to believe an offense happened. The Crown has to have a reasonable prospect of conviction. And if all it was one picture of the pole dancing, I'm not sure it would be in the public interest to lay a charge and proceed with that. However, remember I told you that you could get a peace bond? I would think that where you have a guy who's making available the pole dancing videos, that would give the person in the videos or the police grounds to fear that that person would distribute intimate images in the future. And so we might be able to get a peace bond with conditions that they, for example, not do that. The other thing I didn't mention to you is that at the same time this offense came into place, a new section came into place where people in these materials can contact internet service providers and force them to take down this type of material. And so that might be something else. Okay, another question. Can you clarify what the charge is if an adult is depicted as a child in a picture of a sexual nature? That's a really interesting question. When I first started doing these cases in the early 2000s, I would have said that anytime an adult is engaged in explicit sexual activity and is wearing a baby bonnet and a diaper, that would amount to child pornography. The case law since then, however, says that the person would have to be depicted in such a fashion that a reasonable person looking at the picture would actually think the person was under 18 years of age. So when I teach about this, I often put a picture of this bearded, hairy guy who's clearly in his 40s, but wearing a baby bonnet and a diaper up on the screen. Nobody who looks at this picture is going to believe at all that that person is under 18 years of age. And so whatever he's doing, it's not going to amount to child pornography. But where you're talking about someone who looks like they might be 16 or they might be 18 and a half, and they're wearing a schoolgirl skirt and they've got pigtails in their hair and they're licking a lollipop, and that might tip you over to believing that they're actually under 18 years of age, that's the type of thing that would matter. The other thing that's important is the person who's actually making the recording, or if they're publishing this type of material, they actually have an obligation to take all reasonable steps to ascertain that the person in the picture is over 18 years of age, and where they are over 18 years of age, that they're not depicted as being under 18 years of age. But that requirement only applies to the people who are making the material or who are publishing it, if you will. People who just possess it, the question's going to be whether a reasonable person looking at it would think the person was actually under 18 years of age. If you look at it and you know that it's an adult dressed up like a child, that's not going to meet the definition. Any more questions? Yeah, if there are no other questions, thank you for your attention, and goodbye.